Hello and welcome to Chapter Summary 12, which is over chapters 21 and 22 in the legal environment of business. Chapter 21 deals with employment discrimination and the whole concept of employment at will doctrine. The gist of employment at will is that the contract of employment could be terminated by either the employee or the employer at any time. The exceptions to the employment at will doctrine are implied contract, the public policy exception, an implied covenant of good faith and fair dealings. The laws that deal with employment discrimination are the Civil Rights Acts of 1866 and 1871, the Equal Pay Act of 1963, the Title VII, the Age Discrimination in Employment Act of 1969, the Rehabilitation Act in 1973, and the Americans with Disabilities Act of 1991. If a person would want to file a discrimination case, they would have to prove one out of three things. There was either disparate treatment, a disparate impact, or harassment. Disparate treatment occurs when the employer treats one employee less favorably than another because of the employee's color, race, religion, sex, or national origin. Disparate impact occurs when the employer's facial neutral policy or practice has a discriminatory effect on employees who belong to a protected class. Harassment is most notably known for sexual harassment, which is unwelcome sexual advances, requests for sexual favors, and other verbal or physical contact of a sexual nature that explicitly or implicitly makes subjugation a term or condition of employment, or creates an intimidating, hostile, or offensive environment. This kind of opens up a can of worms to deal with in today's society. There is a precedent going around now that any woman could claim that any man sexually harassed her or touched her, and she would be believed no matter what. My friend Cam has come to the depressing acceptance that at any point his future career can be ruined by any woman. So earlier, I had talked about the protected classes. So, what are they? They are race and color, national origin, religion, sex, or pregnancy. Which leads to affirmative action, which the whole point of affirmative action is to increase representation of women and minorities in the workforce. However, this could lead to even more discrimination in favor, because to increase them, you would have to decrease the people that had normally occupied those roles, which would be white males. And my dad, as some on campus know, is a professor there. But back when he was a full-time professor living down in Florida, his boss came to him and asked, "What have you done for us these past 5 years?" So my dad wrote up a summary of all that he had done for the college during those years. The college then went and Taylor wrote a job description based on my dad's summary. Instead of hiring my dad for that post that he had been performing for the past 5 years, the college then went and hired the female adjunct professor to fill his spot. Then the college called him and asked if he wanted to fill the adjunct position. He didn't have another job yet, and he still said no. Chapter 22 went and dealt with environmental law. And the big agency is the Environmental Protection Agency, which is the federal agency charged with the responsibility of conducting and integrating coordinated attacks on all forms of pollution of the environment. And one of the main things that they have integrated is the Environmental Impact Statement, which is a statement that must be prepared for every major federal activity that would significantly affect the quality of the human environment. The main problem when dealing with environmental law is that the environment is a global area. Therefore, the entire globe would have to be on board with the law and with cleaning up the environment, and it would take everyone working together, and that just might not happen. So this has been a review of chapters 21 and 22 in the legal environment of business.